Okay, well, I make it 10 o'clock. Welcome to everybody who's joined us this morning. Thank you for taking the time out to come and listen to us. As you can see, this webinar is all about emerging from lockdown and the future of working from home. I'm delighted to be joined by Samantha, Randall and Ola McGhee from Palmer's. So Samantha's our associate solicitor, Ola is the solicitor, and we're going to benefit from their expertise this morning in this subject, which I know is close to a lot of business owners' hearts at the moment, and how we go about dealing with this. We will have time for a Q&A at the end. So just for those of you that aren't familiar with Zoom, there's a tool on your toolbar called Q&A. If you click on that, it will open up a panel which will enable you to put questions forward to Samantha or Ola as we go along or at the end today, and we'll try and answer as many of those as we can live. We will also be recording this webinar, so we will make a copy of an on-demand version available on our website later on today. So if you need to recap on any of the points made today, then that will be there for you. We plan to finish round about 10:45 this morning. So without further ado, I will hand over to Samantha to get things started.
Sure, so I think I'll hand over to Ola actually. So Ola's going to take the first half, and then I'll be picking up around sort of midway to take the second half. So hand over to you, Ola.
Thank you, Sam. Okay, well, as we know, lockdown has brought a whole host of surprises, changes and challenges to employers, the length and breadth of the country, but the most prevalent has been the pivot to home working. Office-based businesses and employers have had to, in order to maintain their workforce and their businesses viable, largely allowed staff to work remotely, allowing them to continue working and earning whilst also staying safe, socially distanced, and in many cases caring for their children who are unable to attend school. So during this webinar, we'll be taking a look at some considerations for employers on the following topics: remote home working, flexible working, how employers can make it work, contractual and policy considerations, and finally claims in the Employment Tribunal. Of course, we know that home working isn't a new practice, and prior to the pandemic, about 5% of the UK workforce worked mainly from home. Most large enterprises already offer facilities and options around this for employees who are able to perform their role remotely. However, there's never been such an event that has sparked such mass change in typical work practices, escalating remote working at such a rapid pace. So many employers and employees are facing challenges around this rapid adaptation. Current forms of flexibility are very different from typical flexible working approaches. Many employees are balancing work with childcare, homeschooling and supporting vulnerable relatives, as well as working from kitchens and living rooms. This isn't reflective of normal flexible working, and companies should take care not to make any decisions around flexible working based purely on this. Instead, it is a good opportunity to review the benefits flexible working can offer, but the unusual nature of this situation should be borne in mind. Organisations should be careful not to conflate flexible working and home working. Remote or home working is just one form of flexible working, of which there are many, and the type of home working we have been experiencing recently is not usual. In the short term, as lockdown restrictions ease and many employees continue to work from home or during a phased return to the workplace, it is likely that employers will find that there is a mix of virtual and physical working. During this time, organisations will need to ensure fairness and consistency in the treatment of all employees, whether working flexibly or not, as well as ongoing communication and engagement. What businesses can do following this period of enforced home working is to review the fact that flexible working has many potential benefits for organisations and employees. There is a wide range of research and a strong evidence base for how flexibility can support inclusion, help to reduce the gender pay gap, support sustainability initiatives, attract and retain talented individuals from a wider geographical area, increase productivity, and support well-being. Moving on to the next slide. So I'll cover remote and flexible working now. And as I've already said, the coronavirus pandemic has had an unprecedented impact on employers and society internationally. In recent months, the pandemic has led to a significant amount of the workforce working from home, in addition to accelerating a working revolution following the end of the pandemic that was already underway. involving the use of remote, flexible and gig working options. Many employees have also found themselves working more flexibly in terms of the hours or days worked, often as a result of balancing work and other responsibilities such as homeschooling or childcare. The traditional model of working in the office 5 days a week, 9 to 5, has been with us for a very long time. And prior to the pandemic, flexible working uptake was slow, and it is generally considered the overall demand for flexible working outstripped supply in the pre-COVID-19 world. However, there are now indications that many employees will wish to continue to undertake some degree of home working or flexible working in general after the current restrictions have passed. In April 2003, the UK government introduced the right to request flexible working, and this historically applied to parents and certain other carers. The legislation now includes all employees with at least 26 weeks continuous employment, so that's six months employment, regardless of parental or caring responsibilities. The right to request flexible working, however, doesn't extend to some category of worker, for example, certain agency workers. This raises several practical issues for employers, ranging from practical matters such as subsiding home broadband costs and supplying laptops, to psychological issues such as keeping staff motivated and productive whilst working remotely. Other practical issues include managing video conferencing and training less adept staff in the use of remote working platforms. Technical matters might include IT systems, ability to support remote working, and maintaining security, data protection, and disaster recovery sites. The pandemic has seen businesses adopt flexible working practices at an unprecedented rate. Not only does this protect the workforce and provide business continuity, they support broader official measures to curb the outbreak. Home or remote working can mean people avoid lengthy commutes, have fewer distractions than in an office environment, but can also result in people overworking and feeling isolated. So a focus on health and well-being is essential. Obviously, home or remote working isn't suitable for all jobs, as it's best suited to knowledge work with clearly defined tasks. In some cases, it mightn't be possible to combine elements of remote and office-based site working, or for service or manufacturing staff, organisations might be able to embed more flexible working when it comes to start and finish times or shift patterns. However, whatever the situation, legally, employers have a duty to consider a flexible working request in a reasonable manner and can only refuse a request for flexible working if they can show one or more of a specific number of grounds apply, which will be addressed shortly, and such request must be handled reasonably to avoid any inference of unfairness or discrimination. So moving on to the next slide, what is flexible working? Flexible working describes a type of working arrangement which gives a degree of flexibility on how long, where, when, and at what times employees work. There are many forms of flexible working, including home working, part-time or reduced hours, job shares, flexi-time, compressed or annualised hours, career breaks, staggered start times, and finish times, or self-rostering. It can be formal and part of an employment contract, or informal, agreed between the employee and their manager, and taking place on an ad hoc or occasional basis. UK employment law sets out a number of minimum standards regarding flexible working with which employers must comply. So employers should make sure they're aware of these when reviewing their flexible working arrangements. Moving on to the next slide, to flexible working and the law. As of June 2014, any employee with more than 6 months continuous service may make a formal request for flexible working. I won't bore you with the law on this. They may make only one request in a 12-month period. Upon receipt of a request, the employer has to consider the employee's request in a reasonable manner and within a reasonable timeframe. The entire process should be concluded in 3 months, and that's including an appeal where one is offered. The ACAS guide suggests that it is good practice to let the employee know if there's likely to be a delay in the employer being able to discuss the request with them. Such a request can only be refused on a number of specific grounds. When a request is agreed, it becomes a permanent change to the employee's contract of employment, and there will be consequences if the employer does not follow the correct statutory procedure. Moving on to the next slide, in order to make a statutory request, there are certain eligibility criteria that apply. The request can only be made by an employee. That employee must have 6 months continuous employment at the date the request is made. Only one request can be made under the statutory procedure in any 12-month period, and requests cannot be made by agency workers. Moving on to the next slide. What kind of change can be applied for? Well, if eligible, an employee can request a change to their employment terms if the change relates to a change to their hours, a change to the times they are required to work, and a change to their place of work, as in between their home and any of the employer's workplaces. So clearly there are a wide range of potential work patterns, and the scope of legislation comprises applications for part-time working, full-time working, if currently part-time, annualised hours, compressed hours, flexi-time, shift working, staggered hours, and term time working, amongst others. There are in fact very few limits as to what an employee could request by way of variation. When making decisions specifically about working from home, it's very important to ensure that there's a continuing dialogue between employers and employees to discuss, amongst other matters, which roles can and cannot be done from home, who may or may not want to work from home, and any concerns and how best to handle them. This can also ensure that decisions about home working from home are fair and follow consistency. So moving on to the process on slide 8. You'll see there that there's a diagram about how an employee would request flexible working and how the employer would respond to that. So that's just a key for you to have a look through. In summary, an employee request must be made in writing and must include the following information: the date of their application, the change to working conditions they are seeking, and when they would like the change to come into effect. The effect, if any, they think the requested change would have on the employer, and how, in their opinion, any such effect might be dealt with. And finally, a statement that this is a statutory request, and if and when they have made a previous application for flexible working. When an employer receives a flexible working request, it has to consider it and arrange to talk with the employee as soon as possible afterwards. If an acceptance is intended, then no further meetings are required. The ACAS guide, however, suggests that even where the employer is happy to accept the request, it could be still useful to discuss it with the employer to ensure that the proposal put forward is the best fit for both parties' needs. Doing so will ensure that there's no misunderstandings about what has been requested or agreed. The ACAS code also suggests that if a meeting is taking place, the employee should be permitted to be accompanied by a work colleague and any appeal discussion, and informed about this prior to discussion. The meeting should take place in a private place with no risk of being overheard. And that will obviously assist in gauging a better idea of what changes the employee is looking for, because they may, be reluctant to speak in an open office about their flexible working request. And that will give the parties a better idea of how the flexible working request and the change to the terms and conditions could be a benefit for both the business and the employee. So moving on to the next slide. Consideration of the flexible working request. In considering the request, the employer should look sensibly at the benefits the requested changes could make for the business and the employee, weighing these against any adverse business impact. In considering the request, the employer can't discriminate, obviously, unlawfully against the employee, and must ensure the employee is fully aware of the impact the changes on their terms of employment will be, in particular, if the change may result in a reduction of salary, bonus, or pension entitlement. Employers should also think through operational issues, such as if an employee is going to work from home, will they need to attend the office for meetings, supervisions, and the like? It may be appropriate to include new contractual provisions to address these issues and avoid future confusion. For example, by incorporating a right to request attendance at the employer's premises on reasonable notice. The parties could be prepared to agree a trial period of the flexible working request by the employee, or a variation of that request by way of a trial period. Although the legislation doesn't provide for trial periods, there is nothing to prevent the parties to agreeing to one, as it could be advantageous to both, especially if the employer is unsure about where it's going to be, if it's going to be sustainable, or it's uncertain about the possible impact on other employers' requests for flexible working. So in addition to setting out the arrangements in writing, the ACAS guide recommends setting review points when the parties can discuss how the new arrangements are working and make any necessary adjustments. Moving on to the next slide, and how discussing the decision. Once a decision has been made, this should be communicated to the employee as soon as possible in writing. If it's accepted or accepted with modifications, this should be discussed with the employee to decide how and when the changes can be implemented. Any new work pattern will be a contractual variation and will be permanent unless otherwise agreed. At this point, the employer will need to issue a Section 4 statement, that is, a written statement of changes to the employed terms and conditions that have been provided in accordance with the Employment Rights Act. And this must be provided within 1 month of the changes taking effect. Conversely, if the request is rejected, it can only be for one of the or more of the business reasons set out in the legislation. That is, there's a burden of additional costs, there's an inability to reorganise work amongst existing staff, there's an inability to recruit additional staff, there'll be a detrimental impact on quality, a detrimental impact on performance, a detrimental impact on ability to meet customer demand. There will be insufficient work for the periods the employee proposes to work, and it involves a planned structural change to the business. In selecting one or more of the grounds for refusal, the legislation suggests that the test is subjective on the part of the employer. So if the employer considers that one of the grounds applies, then the test is satisfied. The test doesn't seemingly introduce any question of reasonableness into this judgment. So assuming one of the 8 reasons is given, an employee would only be able to challenge that decision if it was based on incorrect facts. So there are some practical considerations to take into account, moving on to the next slide. So when an employer is in receipt of a flexible working request, it's important to have a written flexible working policy and procedure in place so that the request is dealt with in a timely and reasonable manner. Avoiding technicality points. So a flexible working request shouldn't be just dismissed because of a flaw in the employee's application. So, for example, they didn't set out that it was made in line with the statutory provisions. A better approach would be to advise the employee of the fault, ask them to rectify this on an amended application. If a flawed application is rejected, this will not be looked on favourably by either the employer or any employment tribunal that they decide to take it up with afterwards. Specifically, taking a technical approach to avoid considering an application could simply result in a claim under the Equality Act or a constructive dismissal claim. Employers should demonstrate serious consideration of the requests. This includes identifying potential business issues together with ways to mitigate them. Employers may involve discussing the proposals with the employee's manager and, if relevant, other colleagues. If the employer comes to the meeting showing that they have considered the request seriously, it is more likely that the employee will appreciate that the approach is genuine and feel that engaging in discussions about alternatives where these are possible may be productive. It should also be remembered that in answering the request, if the response cannot be objectively justified, then the fact that the refusal technically conforms to the requirements of the flexible working legislation will not prevent an upset employee from pursuing and succeeding in a claim for sex discrimination under the Equality Act. The next point is that employment tribunals have been critical of employers who appear to have investigated why a flexible working pattern could not work rather than considering how it could. It is important, therefore, to start from a positive standpoint. There is case law concerning claims for unfair dismissal and sex discrimination, one in particular where the employer was criticised for a negative approach towards an employee's request. It appeared to the tribunal in that particular case that the employer had approached the issue by considering why the request could not work rather than how the difficulties may be overcome. Additionally, the employer should consider alternatives rather than only the initial request if it's the case that the initial request cannot be accommodated. It may still be possible to reach an agreement to the satisfaction of both parties. And in such situations, again, the employer should be careful to avoid any inferences of indirect sex discrimination. The wider the options the employee has to consider that are rejected by the employer will result in the employer having difficulty defending the refusal of the request. And finally, employers should be consistent. They should ensure that all flexible working requests are processed and decisions made consistently. This is important where the applicant is of a different sex from those whose requests have previously been granted, or may be able to rely on some other discriminatory distinction between themselves and previous successful applicants. So moving on to the next slide, in the event that the flexible working request isn't granted and the employee wishes to take it further, they should be permitted to appeal the decision. And this again must be considered and decided on within a period of 3 months from the date that the flexible working request was initially received, unless, of course, an extension has been agreed between the employer and the employee. It would be prudent to agree an extension to the decision period where taking account of any trial period and the possibility of appeal if the employer considers a trial period to have been unsuccessful for more than 3 months. It will be required for the employer to notify a final decision to the employee, and so it makes sense that the period will need to be extended. We advise that an appeal can be useful in allowing an employee to speak with the employer about the decision, as this could reveal new information or an omission in following a reasonable procedure when considering the application. Moving on to the next slide, there is also the possibility that an employee can withdraw a flexible working request at any time after it has been made. However, that employee would need to bear in mind that they will be unable to make another request under the statutory scheme for 12 months from the date of that initial request, unless there's an internal procedure which allows more flexibility. An employer will be entitled to notify an employee that it has decided to treat the employee's conduct also as a withdrawal of the employee's flexible working request if the employee fails to engage in the process, or, for example, the employee fails to attend any scheduled meeting to discuss the application, including an appeal, without a good reason. In any case, the employer should notify the employee of this.
Thank you, Ola, for that.
Yeah, I'm handing over to the lovely Sam.
Obviously, Ola's gone through the more formal application process under statutory rules, which, as you'll see, is quite a drawn-out process, particularly if you're going to be dealing with quite a number of flexible working requests, depending on the size of your business. So what I'm going to be looking at is flexible working in the short term. So if we could have the next slide, please. So many employers have had short to medium term needs for flexible working as a result of the current pandemic. So, for example, they might be living with health conditions that have made them especially vulnerable. They may be struggling to balance work and childcare, and they may have ongoing care and responsibilities. So in these circumstances, it may not be helpful to follow the normal policies and processes for requesting flexible working. Employers may also find themselves in a position where they have to consider several flexible working requests at the same time. And in such cases, ACAS guidance makes the following suggestions. So firstly, employers are not required to make value judgments about the most deserving of the request. Each request should be looked at on its individual merits in the context of the business. Requests should be considered in the order in which they are received, though it may not be possible to grant them all. Before a decision is made, the employer will need to consider the impact on the business of doing so. So the employer will need to remember that having accepted the first request to take account of the changes, this will make to the business contacts as to when looking at the next request. So you've always got to be mindful of the impact that accepting those earlier requests are going to have going forward. So the employer might want to have a discussion with employees who have made requests to see whether some adjustment or compromise by all of them can be accommodated, so that you can agree to the most application requests. So if this doesn't provide a solution, then the employer may want to consider the position of those members of its workforce that already work flexibly, and consider whether some adjustment or compromise on their part can be made, so that everyone's requests can be accommodated. So the overriding requirement is ultimately for the employer to deal with requests for flexible working in a reasonable manner. It's important for employers to be consistent with individual requests when in receipt of multiple requests simultaneously, as we might see over the next coming weeks as we come out of lockdown. Where the employer is trying to facilitate several requests at one go, it will need to take account of any particular features of a flexible working request. So this includes things like caring obligations or accommodating a disability, which may limit the employee's availability to vary their working arrangements as they have requested. Despite the suggestion that employers need to make valued judgments about requests that they deal with and the order that they deal with them in, it's almost inevitable that employers are going to prioritise employees who may have additional protection in the form of being able to bring discrimination claims, for example, if their request is rejected. Moving on to the next slide. So in terms of addressing the short-term employee needs, employers need to consider allowing requests for more short-term flexible working or time-limited changes to terms and conditions of employment. Not necessarily, therefore, following the formal statutory flexible working process. So these could include allowing employees to make temporary changes to their working pattern, for example, for a shorter period of 3 or 6 months. And at the end of any agreed period, the employee will then automatically return to their substantive working pattern unless agreed otherwise. Alternatively, a short and simple application process. For example, the aim to make decisions quickly in no more than a week or two, and provide employees with a simple form to complete. So this might be quite handy if you're going to be dealing with quite a large amount of requests, where under the flexible working process may not be suitable for the company from a time constraint. So removing the usual policy requirements might be a consideration as well, such as stipulating a 26 week service in order to make a request, or allowing more than one request in any 12-month period. So you might review the actual formal process and adapt to that to be more suitable in the circumstances. You may well consider outlining specific requests to employees may make, for example, a reduction of hours or flexi time, and have an assumption that requests will be agreed wherever possible, where an employee has a good reason for needing that change. So it's all going to be about flexibility ultimately in the short term. Again, any changes should be mutually agreed, confirmed in writing, and have a clear end date. So where employees are seeking a permanent flexible working arrangement, or they seek one where a temporary change has ended, then the normal policies and procedures should apply at this stage. So anything for a more permanent change will need to be done under the formal statutory flexible working applications. So this more of an informal approach will only be suitable for the temporary short-term changes. Moving on to the next slide. So considering a return to the workplace, as many employers will be over the next coming weeks and months, short-term flexible working may provide support to the return of normal working practice in the workplace. workplace. We will be continuing to live and work with the risk of COVID for many months or years to come after restrictions have lifted, and there may be limitations still on public transport and employees also being concerned about using it. And in order to maintain social distancing, there would ultimately need to be a limited number of people who may be able to return to work in a single office building. So the following forms of flexible working can support social distancing and help maintain hygiene, and therefore supporting an overall safe return to the workplace. So a couple of examples may be home working. So where they can do so effectively, an organisation should allow employees to continue to work from home. Another option may be staggered hours. So a staggered hours system may allow workers some discretion with prescribed limits in fixing the time when they start and finish. So for example, some employees may work 7 a.m. till 3 p.m, with others working 10 a.m. till 6 p.m. So there's not so many people in the office at any one time. Another option is compressed hours. So compressed hours actually allow employees to work their normal contracted hours over a reduced number of days. So a typical pattern would involve 4 longer days and not working on the 5th day, for example. And this pattern could reduce the number of employees in the office on certain days. Another option may be adjusting a shift rotations. So where employees work in shifts, for example, a rotating shift pattern where one group of employees take over from the other. The processes can be introduced to then reduce contact between the different shifts and their employees. And lastly, any 5 from 7. So many workplaces operate between Monday to Friday, where it's feasible to do so, opening 7 days a week and asking or allowing employees to work some of their physical workplace hours on weekends can also reduce the amount of people in the workplace at any one time. Moving on to the next slide. So how can we all make this work? So essentially, in order to successfully implement flexible working, both employee, the team and the company all need to work together, as ultimately any flexible working application is underpinned on trust. So therefore, good communication is vital. It's ultimately a balance between flexibility and facilitating cooperation. Employers will need to set out clear expectations of what is required of their employees. And employers will also need to consider other ways of measuring work and output, which I'm sure many of companies have found over the last year. With majority of staff working remotely, how can you monitor staff performance and measure their output? Moving on to the next slide, coming on to any kind of contractual changes. So some of these working arrangements may differ from those set out in the employee's contract of employment. It's important that employees do not make unilateral changes to the terms set out in an employee's contract. So this is effectively where an employer enforces a change without the employee's consent. Even when such changes are temporary, to do so would amount to a breach of contract and expose the employer to a risk of a constructive dismissal claim. Even when a contract has a clause allowing employees flexibility to change work patterns, care must also be taken, as such clauses can still be used in a reasonable way and must not discriminate against any employee with a protected characteristic under the Equality Act. So, depending on the nature of the changes proposed, employers may wish to seek legal advice on their plans and their organisation's specific contracts of employment. There are several ways that a contract may be changed, but the most effective way is usually by agreement with the employee. Employers who wish to introduce changes to the ways of working should ultimately communicate their proposals clearly to all of their members of staff, including those on furlough leave, and setting out as much practical detail as possible about how long any changes are expected to last. It's also advisable that any relevant trade union representatives are included, or any employee groups are included in those discussions. You should also seek feedback from the employees and provide a way of them being able to ask specific questions or make suggestions. You should ultimately identify employees who may be particularly vulnerable and engage specifically with them, either directly or by creating a group of employee representatives. Of course, the specific personal circumstances of employees should also be taken into account. Some employees may be unable to change their working hours for a variety of reasons, including childcare or family responsibilities. So care should also be taken in these cases to not discriminate. So following communication and feedback, the proposals for change should be set out formally in writing to the employees, and their explicit agreement for change should be sought. Where an agreement is reached, employees may implement the changes, and they should keep any new working pattern under review and be prepared to change them as the situation evolves or as government advice changes. Where employees do not agree to the changes, there are other options open to the employer, and these include imposing changes unilaterally. Obviously, this is a bit more risky, together with terminating any existing contract of employment and then offering re-engagement on the new terms. So ultimately, these actions should only really be a last resort in the current circumstances, and any employer considering this type of action should take legal advice before, just because there is such a higher risk of a claim against the company in that regard. Moving on to the next slide. So obviously, as a result of the pandemic, it's kind of accelerated the drive for flexible working, which was already there simmering away in the background previously. So in terms of what flexible working is going to look like in the long term, there was a government consultation back in December 2019, in which the government confirmed its intention to introduce changes to the flexible working legislation, and what's referred to as flexible by default. So these are where jobs are considered as flexible unless the employer has a good reason to designate them otherwise. So although there are no timescales in place yet, and whilst it's currently thought that employers will still be able to turn down flexible working requests where there is an operational reason to do so, this change in legislation will also raise awareness of flexible working in general. So employers should therefore be prepared for an increased flexible working requests, particularly obviously in the coming months as a result of the pandemic, and if more information becomes available about legislative changes in this nature. So although there's an already established legal framework, the pandemic has obviously led the way for the introduction of more flexible working arrangements in practice without the need for a formal policy or formal request to drive that change. This is likely to continue in the short term and is something which companies should consider carefully. So where there is an organisation is willing to see an increased demand as an opportunity, they may be able to harness a number of business and employee benefits, including productivity, workplace inclusion, talent acquisition, employee well-being and sustainability. So it's important to obviously look at the benefits that this could bring to a company and their employees. Moving on to the next slide, looking at policy. So any change of approach to flexible working, either in the short or long term, may require a review of policy. Where the policy follows the statutory procedures only, the full benefits of the flexible working process may not be fully realised. So, for example, the fact that the law only permits employees to request flexible working formally after an employee has been employed for a period of 26 weeks might actually discourage employees from applying for a new role with a new organisation. Proposed legislative changes around flexible working for all could result in this requirement being removed. So it's, in terms of moving forward, these are things that you might wish to amend in your own policies. So other policy changes that support flexible working might include allowing flexible working requests from day one, so no qualifying period of employment, advertising all roles as open to applications for flexible working, having a simple application process that doesn't require an employee to specify why they want flexible working, having an automatic consideration of transferring existing flexible working arrangements to internal promotions or job changes, and having short timescales for considering any requests. So this is particularly going to be if you're going to be dealing with quite a large number of applications in any one period. So moving on to our final slide, looking at claims in the Employment Tribunal under the statutory scheme. So subject to the rules on ACAS early conciliation, a claim under the scheme must be ultimately presented in a tribunal within 3 months of the relevant date on which the first date in which the employee became entitled to bring a claim. So within such further period as the tribunal considers reasonable, where it's satisfied that it was not possible to bring that claim in an initial period of 3 months, then obviously the tribunal will have discretion to extend this. The tribunal can only examine an employer's decision to a limited degree. They can only make very low awards of compensation in this regard. Whilst compensation under the statutory scheme remains limited, there is a relationship between flexible working requests and other forms of statutory protection, particularly where it comes to discrimination legislation. And this is what needs to be taken into consideration when dealing with these requests. Fundamentally, the difference is that the legislation governing the statutory right to the flexible working request offers little room to examine the commercial rationale, whereas in a claim, for example, of indirect sex discrimination, the reason why the decision has been reached is fundamental to establishing whether the decision can be justified. Typically, these requests will be made by employees wishing to vary their hours to comply with either childcare commitments, either on return from maternity leave, religious requirements, so for example, not wanting to work on a Sunday, or being allowed time off to pray or attend worship, and those who are seeking adjustments because they are disabled. So the tribunal cannot question the commercial rationale or the business reason behind the employee's decision to refuse a request, and neither can the tribunal substitute its own view as to whether that request should have been granted or not. This severely restricts the scrutiny to which an employee's decision may be subject to in such claims. However, it is essential that the tribunal's role is therefore restricted to reviewing the procedure followed by the employer, considering whether the request was taken seriously, considering whether the decision was based on the correct set of facts, and considering whether the reason given falls within the permitted grounds, so the specific reasons as to why you can refuse a request. So to date, there has been limited cases brought where a claim for breach of the statutory right to request flexible working has not been accompanied by a discrimination claim as well. For women, this has proved an effective remedy. It is possible for claims to fall under the statutory right provisions, but to succeed as a sex discrimination claim. Nevertheless, the approach may not help men seeking to work flexible in order to care for their children, or help a carer of either sex who is seeking to work flexibility to care for an adult. Both men and women can make requests for flexible working under the statutory provisions. Historically, most employers tend to look more favourably on requests by women than those of men, a practice which could expose the employee to claims of sex discrimination by men. If a request to work flexibly is not considered seriously because it comes from a man, when the same request made by a woman would have been properly considered, then a claim for direct sex discrimination would succeed on this fact. With respect to disability discrimination, if an employer has an employee with a disability, the duty to make reasonable adjustments for that employee does arise. This means that the employer must effectively treat that disabled person more favourably than others in making an attempt to reduce or remove that individual's disadvantage. One way to do this might be altering that employee's hours of work, by which the employee may ask for by making a flexible working request. Now, the Employment Statutory Code of Practice, which tribunals must take into account if it appears relevant, contains a non-exhaustive list of all of the potential adjustments that an employer might be required to make. And one of these potential adjustments is to alter the disabled person's hours of work, which suggests it could include allowing a disabled person to work flexible hours to enable them to have additional breaks to overcome any fatigue arising from a disability, or permitting part-time working over or different hours of work to avoid the need to travel in rush hour, for example. Moving on to the next slide, when looking at remedies in the tribunal, so where a tribunal does find that a claim under the statutory provisions is well-founded, it must make a declaration to that effect, and then make either or both of the following. So one would be an order for reconsideration of that request. So if it does this, the date of the tribunal's order will be treated as the date of that request. Alternatively, an order of compensation to be paid to the employee may be granted, and such amount as the tribunal considers just and equitable upon the permitted maximum of 8 weeks' pay. So the maximum amount of compensation is 8 weeks' pay. This is solely looking at a claim under the statutory requests only. And obviously that isn't taking into account any injury to feelings if such claim is brought together with a discrimination claim. And that brings us to the end of our webinar. So I understand we will be taking a couple of questions.
Great, thank you very much. Well, we have had some questions coming in. So first one here from Ian, thank you. Should employee contracts be changed to reflect the mixture of office and home working?
Yeah, so I think we covered this a bit earlier in I think in Ola's section. So particularly if you are going to need employees to come into the office for meetings or supervision, that kind of thing, then you might want to have a clause in their contract that just gives you the right to be able to request them to come in to the office on that basis. So it gives you a bit more flexibility as to when you need them in or not.
Okay. I have had a question from Tracy as well. Will we be sharing the process slide? But as I mentioned earlier, we are recording this webinar, so that slide will be part of the on-demand version, which we'll have on the website later. So a long answer to say yes, Tracy, we will make that available. Question here from James. What is the impact of employee contracts of the company in introducing hybrid working?
So in this case, it's probably going to just be, it's more going to be policy in terms of handbooks that would change. So whether a company looks to roll out a home working policy that's a bit more flexible as a separate to the flexible working under the statutory scheme. Contracts that's in itself won't necessarily change too much unless you're going to change the place of work section to just have that flexibility between a home and an office address. but otherwise it's mainly going to be a change to the handbooks.
Okay, thank you. And just got time for one more question. Again from James, thank you. What are the health and safety requirements of the employer for employees working from home where this has been requested by the employee?
Well, you will need to do a risk assessment on the home working environment, and that is basically a form that you can provide your employees to confirm that they have a safe area to perform their working from home.
Okay, so is that a form that the employer just draws up?
The employer would provide the form to the employee, yes, and then once it's submitted back, then a review of that assessment would take place, and it would be decided whether that employee does have a safe area within which to work, and then a further decision will be made further to that.
Okay.
Very, very similar to kind of risk assessments that you'd have if you're an office-based worker anyway. So things like making sure your monitor is at the right level, no problems with your wrist,
seat is
correctly, you've got good lighting and things like that. So it pretty much exactly the same risk assessment that you do in the office, but at home essentially. So, you know, this might bring up further factors that they might have. You know, they might not be sitting on the correct chair, they might not have good lighting or good temperature. So this might, you know, lead you to want to either provide equipment to counter any issues that they may be suffering as a result. Okay.
In terms of that form, is that something they can come to you for help with to put that form together? Yeah,
of course.
Squeeze one more in from Tracy. Do we know if there are any tax implications of working from home? I don't know whether you can answer that actually. Are there?
I think there's a tax benefit for employees that work from home. That they can claim through HMRC. I think there's two ways of claiming. You can either claim direct through the company, or the employee can claim via HMRC directly. I think there's a base level in which they can submit an application and it not need to be assessed in terms of providing receipts or anything like that. But if it's a more substantial expenses for working from home, then that will need to be accompanied by receipts, bills, that kind of thing.
Okay. All right, well, that brings us to the end of our webinar today. Thank you for all of your questions that you put forward. Thanks very much to Samantha and Olive for your presentation. As I mentioned earlier, this will be recorded, be on the website later on today, and thank you all for attending.